Bismillahirrahmanirrahim. The topic of our discussion in the Ghuzi mood is the right of access to justice in the legal framework of Pakistan. Dear friends, the right of access to justice is considered as included as an essential component of the right to life that has been envisaged under Article 9 of the Constitution of Pakistan 1973. And provisions of Section 28 of the Contract Act declares that any agreement that puts an absolute restriction on the right of people to access courts or limits the time for such recourse, that agreement is void and would not be enforceable by law. Any agreement, any contract which restricts the people to access to the justice, to access to the court, is void by law. And that agreement or contract cannot be enforced by law. Section 28 of Contract Act is elaborating different void contracts, void agreements. Basically, the right of access to justice covers entitlement of a fair trial and by a neutral arbiter. And this specific notion has been discussed in a landmark judgment of Aftab Shabhan Mirani versus the President of Pakistan, reported in 1998 SCMR, page 1863. Basically, the concept of access to justice to everybody has evolved from the concept of due process of law. And right of access to justice encompasses a right to have a fair treatment in line with the existing law and a right of hearing by an independent and neutral court. It is the basic ingredient of the doctrines of the natural justice that no one should be condemned unheard. And this specific portion has been interpreted in a landmark judgment of Muhammad Nadeem Arif and others versus Inspector General of Police, Punjab, Lahore, and it was reported 2011 SCMR, page 408. Basically, you people know, right of access to justice implies opportunity to one person to avail him of legal remedy before courts or other quasi-judicial authorities that are recognized by the legal framework of Pakistan. And this notion was specifically discussed in the landmark judgment Benazir Bhutto versus Federation of Pakistan, reported in PLD 1988, Supreme Court of Pakistan, page 416. As such, establishment of the military courts was maintained to be not in accordance with the law, with any form acknowledged by the supreme law of the country. And military courts are always considered a hurdle in the line of democracy and in the line of basic rights, fundamental rights of the people. So, access to justice is the fundamental right that has been emphasized under the Article 9, right to life, right to the security of person, that has been specifically interpreted in a landmark judgment Sheikh Liaquat Hussain versus Federation of Pakistan, that was reported PLD 1999, Supreme Court of Pakistan, page 504. Dear friend, for efficient exercise of the right of access to justice, the importance of neutral and just judicature is a must and foremost established by the government cannot be substituted. When the natural justice prevails, when the divine law prevails, the right of access to the justice will be secured in the country. And that specific notion was discussed briefly in a landmark judgment, Mehram Ali versus Federation of Pakistan case, reported in PLD 1998, Supreme Court of Pakistan, page 1445. You know, the right of access to justice has been also elaborated in the landmark judgments of the Asad Ali versus Federation of Pakistan, that was reported in PLD 1998, Supreme Court of Pakistan, page 161, and the landmark judgment of Al-Jihad Trust case. Al-Jihad Trust case was reported, PLD 1997, Supreme Court of Pakistan, page 84. And Al-Jihad Trust case and Asad Ali case, it was held the strengthening of the judicature is an integral part of the right of access to justice that can be obtained by the appointment of the people of good name and high level acumen. Absolute freedom can never be granted to the executive in the matter of delegated legislation so as to enable it to frame rules that may have the effect of ousting the legal authority of courts to judge the legality of any kind of administrative action. And administrative authorities could not be given the vast powers of the delegated legislation, and they cannot be allowed to usurp, to infringe the basic and fundamental rights of the people of Pakistan. And it was also interpreted in a landmark judgment, Ghulam Jelani versus Government of West Pakistan, PLD 1967, Supreme Court of Pakistan, page 373. Now, the legal position appears to be formulated on the strength of the right of access to the justice. It was held in the Faisal versus the state. It was also a landmark judgment. It was held that to have the services of a counsel of his choosing, or in the case of non-affordability, to have the services of a state counsel on the state expenses is a must for proper enjoyment of the security of person given by Article 9 of the Constitution of Pakistan 1973. And that was reported Faisal versus the state, PLD 2007, Karachi High Court, page 544. And that was also interpreted in the Sheikh Faisal Hussain versus Federation of Pakistan, PLD in 1999, for Supreme Court of Pakistan, page 504. Dear friends, in order to discharge the right of access to justice satisfactorily, time has to be provided to a person accused of an offense to repel the accusation attributed to him. He should be given the time, he should be given the opportunities to defend his charges. Otherwise, no justice. Otherwise, only arbitrary action, not the justice. That has been interpreted. Aftab Shaban Mirani versus Federation of Pakistan, page that was reported in 1998 as CMR, page 1863. As you know, right to access to justice, and the court is considered a component of the right to life. Right of appeal is similarly held to be a component of the right of access to the justice. And many of the, I feel, many of the cases have been are giving the right to appeal to a person, and against arbitrary, against uh, any type of void order, any type of unlawful order, whatever he feel. In Pakistan, certain laws and portions thereof has been held as the contrary to the supreme law teachings of Islam, discernible from the Holy Quran and Sunnah. You know, a few clauses of the Press and Publication Ordinance 1963 were held to be contrary to the teachings of Islam. You know, as they did not recognize right of appeal, and such type of laws which are restricting the right of appeal are against the basic teachings of Islam, against the basic teachings of divine law, against the basic teachings of the natural justice, and basic against the fundamental rights of the people of Pakistan. And that specifically has been interpreted in the Federation of Pakistan versus Public at Large case, PLD 1988, Supreme Court of Pakistan, page 202. And you know, some times ago, there was a hot news on media. The clause of Section 33 of the Pakistan Army Act 1952, that is not giving the right to appeal to the people of Pakistan, and provisions of the Section 162 of the Pakistan Air Force Act 1953, and Section 140 of the Pakistan Navy Ordinance 1961, you were found to be in contravention of the Islamic jurisprudence on the same score, because they don't want to give the people, they don't want to give the accused or charged person the right to appeal. And that is against the Islam, that is against the divine law, that is against the teachings of the natural justice, that is against the fundamental rights of the people of Pakistan. And that issue has been described Pakistan versus General Public, PLD 1989, Supreme Court of Pakistan, page 6, and Federation of Pakistan versus Iftikharuddin case, that was interpreted in 2000 SCMR, page 1, and right of access to justice is the fundamental right, just like the right of life, and right to life basically covers all the phases of quality of life, and right of access to life is one of them. If there is no justice, there is no life. Pakistan Zindabad. Thank you. Allah Hafiz.